Yeah, I know, I tried to think that.
I don't
I
need electric filters.
I guess we might as well start our first subcommittee meeting of the morning. This is House Bill 267 relative to criminal record checks in school employment. And this was brought forward by Joe Alexander, Representative Joe Alexander, at the request of his Goffstown superintendent, basically to allow for more periodic background checks of employees within the school district. And we did get an amendment from Joe Alexander. I did not bring a hard copy. If anyone has a hard copy or have it, can you bring it up, Katie? Representative?
I just don't know how, you want me to send it to HCS?
Or can you just read it, just the,
I'll read
the,
the changes.
yeah, read the changes?
So the changes begin on, let me see, this, well, I'll just read line, starting with line 20. The superintendent of the school administrative unit or the chief executive officer of the chartered public school or public academy may negotiate with the respective union for that school administrative unit, chartered public school, or the public academy to allow the superintendent to conduct criminal history records checks on a reoccurring basis after the initial criminal history check is conducted for purposes of employment. Any such criminal history records check shall comply with the procedures set forth in this section. I'm trying to remember where this change actually begins. Oh, here are some definitions and some language regarding which particular schools would be,
Right, right.
this would apply to.
Yeah. Because I think part of our original discussion was that contract negotiations would have to be involved in the process, which was not in the original bill that was brought forward. And I know that Attorney Fenton had worked on this amendment. And she, I got a message from her. She is on the way. She's a few minutes late. But this amendment does address that. And I checked last week with the superintendent, Baki from Goffstown, and he confirmed that the reason that he was interested in this legislation and had approached Representative Alexander was because he did try to go the union negotiation route, but received, there's Attorney Fenton, did not receive a favorable response to entering negotiations to allow the more frequent background checks, and it was cited that there was nothing in statute about more frequent background checks. So that was the reason that he put forward this amendment. Attorney Fenton, would you like to talk about the amendment that you had drafted? Representative Alexander sent it to us the other day, and it was just read to us that we neglected to bring hard copies.
Good morning.
Come on. Thank you. Well, just because Katie felt like a problem.
Um, So Attorney Fenton, while hard copies are being made, as I think I mentioned, Representative Alexander did email the amendment to us. And I was just wondering if you would like to, I believe you drafted this for him, if you'd like to comment on it.
Certainly. Good morning. For the record, my name is Diana Fenton. I'm an attorney with the Department of Education. I apologize for running a few minutes late. I was in a meeting with Frank, so as I like to say, it's Frank's fault that I'm late. And if he's watching this, I apologize. So good morning. Thank you for your time. At the last hearing, I want to make clear, it was brought to my attention that my testimony was interpreted as being against the bill, and I want to be clear with this committee that as a state employee, I am not here to express an opinion for or against a bill, that I'm only here to provide technical assistance. I'm not a political appointee. And so if my testimony was received that way, I do apologize. I was just here to provide information. I was asked by the sponsor and the superintendent who was interested in bringing this bill forward if I could redraft it, and I did. I put some words together that I thought addressed his concerns. And so the amendment affects RSA 189.13a. It's earlier in the chapter, and it simply allows for the superintendent to enter into that negotiation. As I testified last time, it really has no impact on the Department of Education. It's simply a matter of employment. It has nothing to do with what the department oversees. But I know there were a lot of questions last time. I'm happy to answer them to the best of my ability.
Thank you for being here, and thank you for taking my question. In your capacity in working with the department, how many incidents have you come across where this has been a problem?
Thank you for the question. And a problem in what in particular?
Well, how many times have you had a superintendent contact you with this issue?
Expressing a desire to do
Yeah.
a more frequent background check. Truly a very small handful, less than 5, I would say. And those are just all anecdotal examples.
Now, thank you. If there is a problem with, it's just a follow-up. If there's a problem with an employee, they get arrested or whatever the situation, isn't there current law that mandates a recognition or at least a report of that incident?
So if someone is arrested for one of the disqualifying offenses that's set out in statute, under the code of conduct, they have to report it to their superintendent, yes.
So if I had another follow-up, excuse me. So if I had been a senior employee and been there for 20 years, and I did something that would violate the code, et cetera, it would mandate that notice would then have to be given, correct? It doesn't get pushed under the rug or anything like that.
So I'll just clarify your example if I may.
Yes.
If you are a long-term employee at a school district and you were arrested for one of the disqualifying offenses, you would be required to report that to the superintendent. There could be additional school policy which would require you to report any type of arrest. I suppose that would be possible, but that would be a local policy issue.
So when the superintendent was here before us earlier this session, he was concerned about, I think, particularly those senior employees that were there prior to his being hired, as I recall. And he was concerned about the ability to have another background check. Is that necessary if in fact, when you're initially employed, there is a background check that's made, correct?
That is correct, yes.
What would be the incident rate? I mean, what would be the reason for wanting to have another one just because as a superintendent, well, Mel's been here for several years, I want to check him out?
Well, let me clarify my answer a little bit. Under the law as it stands now, RSA 18913A, upon employment, there is a background check. I cannot speak to what the law was 20 years ago when someone was hired. And as to what would be the reason, this is not a bill the department has requested to be brought forward. It's hard for me to testify as to why someone else wanted to bring this bill forward. I think my role here is somewhat limited. I can answer some technical questions. I can testify as to why I wrote what I wrote. But again, speaking on behalf of someone else, I think the intent, the desire, if you will, was simply to have the flexibility perhaps to work that into a negotiation. But I'm not going to go any further in my testimony than that.
Thank you. As I read this language, would you say that this is permissive language, enabling language?
Give me 1 second to have my computer warm up. I can,
Okay.
can tell you exactly. My thought when I wrote this was to make it a local control issue, first and foremost. Absolutely 100% falling within the realm of employment, nothing to do with the Department of Education, and to make it permissible only, not a mandate in any sense of the word. The thought was to leave an enormous amount of flexibility to the local districts to enter into this negotiation with the union if they would like to do so. As you can see, I think these are very broad parameters. The department did not craft anything that gets into a lot of detail. That was the intent that was expressed to me, and that's what I tried to capture here. Again, keeping in mind, I play a unique role here. This is not a department-issued bill. This was just a request. Sure. That's my understanding.
Thank you. Any further? Yes.
Thank you. I had a note from the initial discussion about this bill that's not resolved in my head regarding whether this only applies to groups of employees or whether it could in fact single out an individual.
Yeah, thank you for the question. That was certainly a concern that I echoed at my prior testimony. And I think the bill that was previously before this committee, I think there was some potential for that. The way I crafted this, my hope was to make it, as I previously testified to, an exclusive local control issue that they could negotiate out so they could address those concerns. I share your concern that this allowance, if you will, could be used to target an individual. I don't think anyone has expressed that to me, and I would be remiss if we saw it used that way. So I wanted to craft it very broadly to allow for those local negotiations to occur so that at the local level, they could make sure that that didn't occur. They could make sure that it was broadly applied and not targeted at a particular individual.
I appreciate your explanation of the intent of what was crafted. Makes sense. And I still kind of wonder if it would be better if it specifically said something along the lines of nothing in this law shall be used to require an individual to have a records check distinct from the group calendar or group whatever process. Thoughts?
I would not be opposed to that. I certainly think that is well within this committee's decision to add in that additional language. I think what I have created is really a framework. And within that framework, could you add those pieces that you feel would add protection? Yes, that's certainly within the realm of this committee to do so. I think the way that it is crafted, I trust the negotiations at the local level to address those concerns. But certainly this it is well within this legislative body's prerogative to add in those.
Representative Luno.
Thank you very much, Mr. Chair, and thanks, Diana, for being here, and also for sending over the draft amendment. In reading it, would this sort of secondary or more frequent check of criminal history only apply to employees who are members of collective bargaining units?
I think that would be the appropriate application of this, because it's to be negotiated at the local level. And so it would, in theory, only apply to those individuals who are in that negotiating unit, yes.
Okay, so follow up on that. So it wouldn't apply to, let's say, an office manager in a public school who may not be a member of the teachers or support staff union. Some are, some aren't. And it wouldn't apply to the director of student services who operates under a directly. I mean, the director of student services typically will have an employee contract, but that would be a one-on-one negotiated with the superintendent and the school board.
How I read the language.
Okay.
I'm biased, perhaps. But I think the whole idea was to allow that local level negotiation to occur. And to have those individuals who would be subject to this additional background check have a voice in that with their union.
But and just a final question on this string, and so it would not permit the superintendent or head of school to make more frequent background checks a condition of employment, other than as a condition of employment for an employee who is a member of a collective bargaining unit or has a contract as a result of that collective bargaining unit.
I think as I'm puzzling this out a little bit, if we look at the reason the superintendents are, I don't want to speak in the floor. The reason this bill is before the administrative committee is because superintendents feel that they don't have the ability to run a background check currently after that initial. And so this is that permissive language that they are required to have, because the Department of Safety cannot disseminate the federal background check without statutory enabling language. This is narrowly tailored, I believe, to just allow it at the local level with the union discussion, right? I don't think it would be broader than that. Because again, you have a few layers of protection. This talks about the respective union for that particular district. And then the Department of Safety can't disseminate the record without this enabling language, which again, I think is narrowly tailored to just that group of people who are represented.
So So the reason I'm bringing this up, Mr. Chair and Ms. Fenton, is because, like, for example, the school that serves the largest number of public school students in the state, by far, I don't believe has collective bargaining. So this wouldn't even apply in the situation of a school that employs and I'm, by virtue of the number of students that they serve, probably more teachers than any other school in New Hampshire. So I guess I'm sorry I was a few minutes late, but I'm wondering if this is such a big problem, I would think it would certainly be a problem that would manifest at a larger school as opposed to a smaller school. And this wouldn't even apply to the largest school in the state.
And with all due respect, I'm not sure if there's a question there, but I understand where you're coming from. This is very narrowly tailored. And I was asked by the superintendent of Goffstown if I could work with the language that he had initially proposed. And I, again, want to be clear in my testimony, this is not a department-sponsored bill. This is not a request of the department. And the department has no opinion as to pro or nay on this bill. But this committee had a lot of questions. I was happy to try to bring something before this committee that might be palatable. It is certainly within this committee's discretion to vote yes or no for it. The Superintendent's Association is not here to talk about this bill. I don't know how far-reaching this is. I know what I was asked to do, and I brought it forward to see if this could gain some traction, to see if it could address some of the concerns. And I think your point is well taken. It's not supposed to be broad-based. It's supposed to be very narrowly tailored, as was requested. Just that ability, that was what was expressed to me, give the superintendent the ability to enter into that negotiation with the union. I think that's what this bill addresses, or at least that was certainly my intent. Does it address all the corresponding issues that could come from that? I don't think it does. That's not what I was asked to do.
Any other questions of Attorney Fenton? If I could just,
I do have one.
okay.
Good morning.
Good morning.
You spoke just very briefly just now that this appears to be a singular issue coming from Goffstown. You don't know where the Superintendent's Association is on this. So that's my first concern. Is it wise for us to build legislation around a singular district, or should we be doing something that's applicable statewide? And secondly, I have the question, are there any employees within school districts that you know of, whether they're certificated or not, that require more than one criminal background check other than the initial for hire? What about school bus drivers? What about other employees that, well, can you just answer that? Do you know of any other employees that require more than one check?
Let's put bus drivers aside
Yeah.
for a moment. You said indeed moving.
No, off the top of my head, I mean, the way the statute is written, for purposes of employment, a criminal background check is done at the time of employment. And that's for contractors, that's for certified educators, custodians, school personnel across the board, even volunteers. Designated volunteers are subject to the same level of background check. With newer educators, they are now getting a background check upon licensing because the department does not want to license someone who might be unemployable. And then they go into employment, and that background check at the employment level can be more thorough. It goes beyond the disqualifying offenses. And so to answer your question in that way, yes, now there is that two-tiered approach of background checks, but for employment purposes, I can't think of a group of individuals who are subject to more than one background check upon employment.
Thank you.
With, as you just said, with the employment background check, it's more comprehensive. So you get to see misdemeanors,
Correct.
et cetera. And what we're talking about here would be an employment check rather than a licensing background check, criminal record check. So if that initial employment check is done only at the initial certification, additional licensing, there could be misdemeanors that a person would be convicted of over the years that a superintendent or a district might consider questionable based on that person's status and the nature of the misdemeanor over the years. And those things would not be caught necessarily at this point. Is that correct?
That is.
It seems to be going off periodically.
That is correct. And if I may explain, the background check that is done currently by the Department of Education is only for those disqualifying offenses. Anything that would make someone unemployable by statute. The department's policy is the department does not want to license an individual who is statutorily unemployable in our schools. That being said, when we pivot away from licensure and we look at employment, Representative Cordelli is correct. School districts, by statute, are allowed to be much broader in their discretion. They are still subject to the disqualifying offenses, as is the department, but they can create a policy that allows them to account for anything that is found in that criminal record. The other important piece for this legislative committee to consider is to recognize that 189.13a has been changed dramatically over the past 8 or 9 years. And 10 years ago, school districts were not receiving criminal records. 10 years ago, school districts were not subject to this information. 10 years ago, and I'm using that number broadly, but it's a good milestone. 10 years ago, it was the Department of Safety that would read through an applicant's criminal record, and they would then send a letter to the school district and say, and it was a binary option. Yes, you can hire. No, you cannot. And so as this legislative committee considers this bill before it, I think it's important to keep in mind that the nature of criminal history checks has changed dramatically. So people who were employed 20 years ago were subject to a very different analysis than individuals who are hired today or even 3 years ago. This legislative body has made dramatic changes in this area of the law.
If I could follow up, so for an employee who was hired 10, 15, even 20 years ago, the statute has changed in terms of offenses and disqualifying offenses, et cetera, which probably or possibly could not have been caught back on the initial criminal record check. But this would allow, through a negotiation process, to do a new background check and possibly look at what is now a disqualifying offense. Would that be the case?
Yes.
And one more follow-up. I think you just brought it up a minute ago, in that in this district, if the union had agreed to negotiate more frequent background checks, that would have been one step forward. But because there was no language in statute, they could not get the FBI data from the Department of Public Safety. Is that also correct?
That is correct. The Department of Safety cannot disseminate the federal background check to a school district or to the Department of Education for that matter, without enabling statutory language. Simply put, it has to be in the book. It has to be allowed for DOS, Department of Safety, to then disseminate that record to a governmental entity, i.e. a school district or a state agency.
So the real purpose of this enabling or permissible language is to allow for the district to get that FBI language.
To receive the record?
Yes. Yeah.
Yes.
Representative Myler.
What's the fee for running a record check now?
Oh, gosh. I'm going to ballpark it, and it really is a ballpark figure. I believe it's around $50. And I think there is language in the statute currently that says the school district may require the individual to pay that, or the school district picks up that cost. And each district, that's a local policy determination.
Yes, Representative Luno.
Thanks very much. And a follow on to that, if an employee, actually, let me back it up further than that. If an individual wanted to contact the Department of Safety and get an FBI background criminal history check on themselves, could they pay $50 and do that and then get the report directly from the Department of Safety?
You think that would be the answer. The answer is I don't know. There's been mixed information on that. The FBI, my understanding, and again, I don't work for the Department of Safety, and they've been half or preserved. My understanding is that there are regulations by the FBI that would prohibit, I'll use myself as an example, from contacting the FBI and saying, hey, I'm going to take a look at my own record. Here's my fingerprints and my money. If it's just supposed to do that, they disseminate it only to another state agency. I could be wrong. I don't want to speak, but my understanding is that has been problematic. The reason it came up and the reason I know we struggled with it is if you take a private contractor, for example, Diana's janitorial services. That is a non-governmental entity. They're not subject, they cannot receive the FBI background check. They can get the New Hampshire background check. I can go on to the New Hampshire portal and type in my name or type in my neighbor's name and receive their New Hampshire criminal record. But that is limited to the state of New Hampshire. And so when we saw all these various changes occurring in 18913A, part of the driving factor, Representative Luno, was the recognition that a private company, i.e. Diana's Janitorial Services, can't receive the full background check. I can't get the federal background check. But the Department of Education can, because it is a governmental entity. SAU 1 can, because it is a governmental entity. We saw this with Brewster Academy and all non-public, sorry to pick on Brewster Academy, but Brewster Academy is not a governmental entity. And it wasn't getting the FBI background check. We worked with the feds to get them an exception under the Adam Walsh Act because it is a child safety issue. So that's how I have become aware of some of those regulations which would prohibit individuals from just calling up and receiving it. Because if that was the solution, we could say to all the individual contractors, just call the FBI directly and request it. It is an issue of dissemination. And that's what the FBI is concerned about. And again, I'm not here to speak on behalf of the FBI, is my understanding.
Just a quick follow-up on that. Well, it may not be quick.
Thanks for the warning.
Well, the follow-up part, but the answer may be, so this exception for non-government entities that you were just talking about, What does that apply to?
The exception is just under the Adam Walsh Act. And that was just for those non-public schools to have access to the federal background check. But that's not necessarily applicable to,
No,
private company.
but they would have access to the federal background check through the Department of Education? Because they can only, I thought you said they could only disseminate to a government.
they can only disseminate to a governmental entity or another entity that is allowed under the Adam Walsh Act.
Okay. All right.
And a good example of the Adam Walsh Act, putting aside the non-public schools, like a camp, any program that works exclusively with children, my limited understanding of the Adam Walsh Act is it is that child safety exception.
And I knew there was a reason I was asking this. Can they do that on an annual or more frequent basis, or only as a condition prior to hiring the employee?
My understanding is the way the law is written, it is upon employment only. I do not believe it would be allowed for a reoccurring basis.
Okay.
But again, I'm getting pushed out of my comfort zone a little bit, so I'm going to put an asterisk next to that testimony because I don't work for the FBI. I don't know all their regs. It is really a cursory understanding, and I don't want to mislead you in any way.
Oh, fair enough.
That
Thank
is
you.
my understanding of it.
Thanks very much.
Thank you.
Representative Ladd?
Maybe I can push you back into your comfort zone here.
That would be great.
On lines 20 and 21, you speak about the superintendent of the school administrative unit or the chief executive officer, but on line 23, you only speak of the superintendent. Is that the second line, should it read, or like you have up top where
Yes.
there may not be a superintendent in a charter school?
Yes, that's simply a typo.
Where you left out the four words, five
Yes.
words. Okay. Secondly, if this were to pass, are we now setting up a situation where you have some districts that are not able to do this, there is no union, and those that are, which have a union? Is Peter going to start coming after Paul and say, hey, you can do it, so why can't I do it as a superintendent or chief administrative officer? Should we, if we're doing something like this, should we make it then more statewide to involve all districts? But we're only involving those districts are union districts. That's the question. And there's two questions. You answer the first one.
If it is this legislative body's intent to have it applicable to all districts, then this language that is before you currently would not suffice. It's really a policy determination to say if it's going to be applicable to all or to defer to local control. And that would be beyond the scope of my testimony.
Okay, I'll follow that up if I may then. So the intent or the rationale behind this is for a superintendent to address an issue which he feels or she feels that's necessary. Wouldn't that same situation, might that same situation occur in some other district that didn't have a union?
The answer to both your questions is yes.
Thank you.
Any further questions for Attorney Fenton? Representative Myler?
Rick raises an interesting issue for me, and that is, if there's an issue, I mean, if an incident occurred that would need a records check or something, isn't there some other form of discipline or progressive nature of discipline that would address this, or even fall under the code of conduct that would trigger this kind of a thing? I mean, I'm just concerned about this law enacting a piece of legislation, kind of what Rick was saying earlier, where you have one superintendent who's come forward and I got a problem here. And then all of a sudden, everything. So My question is, excuse me, the question is there, if there is an incident that would cause some concern, aren't there other factors that a superintendent could follow rather than having the necessary, say, oh, now we got to sit down and negotiate this?
I'm going to push back on your question just slightly, simply because you're making it targeted at an individual. And that's not what this legislation was designed to do. This legislation, if used in accordance with its intent, would be more broad-based and shouldn't be used to address, as you say, a problem with an individual. That was certainly not my thought when I spoke to the superintendent. That's not what was conveyed to me, and that's not the purpose behind this, as far as I understood it to be. So I push back only because I think you're talking about a particular fact pattern in an individual, whereas this is not intended to be applied that way. I hope that helps. Thank you.
I'd like to follow up.
Sure.
And I'll follow up on Representative where we were just now, dealing with the issue of broad base. But this legislation is allowing the local school district to decide this employment issue, whether it's targeted towards an individual or a broad base. It's going to be determined by that negotiation. So when we say that, but this is not necessarily broad based, we don't know.
You're right. I would certainly hope that, what was expressed to me was not a desire to say, well, there's a problem, I need to conduct another background check on Diana Fenton, problem employee. The thought was, I want to, as a superintendent, be able to negotiate this possibility with the union, not to say, well, now I need it as a tool and now I want to administer this. And so it was to put it as part of contract negotiations, along with a whole host of other issues. Now, could a superintendent utilize it in those contract negotiations? I suppose they could, and I will defer to the union to testify to this, but my understanding is when you have those contract negotiations, they are more broad-based, more broad-arching. It's not about an individual. And again, that's just my understanding of it. So I would be surprised if this was to be used to address a grievance with one particular individual. That's not what was expressed to me when I spoke with the superintendent. And again, limited knowledge base, but that is the spirit in which I drafted this amendment. And it is certainly within the purview of this committee to make modifications.
I'm somewhat concerned about where we're going with this. If I'm the teacher on a playground, I'll give an analogy here, and there's a individual screwing up on the yard. Do I line the whole playground kids up on the wall or the one kid that's screwing up on the wall? It seems to me whether if the effort behind all this is to deal with an individual, this is the wrong way to do it. We're passing some legislation that's a blanket for groups, what have you, rather than dealing with the specific issue. So I'm a little bit perplexed as to where we're going with this in terms of what is the initial intent and the purpose of this? What is the end of this? What's that end zone look like? Where are we going and why?
My understanding of the spirit of this proposal was that it was supposed to be proactive in nature, not reactive. I think state government is infamous for being reactive and not proactive. And the thought from the superintendent, and again, it's difficult to testify on someone else's behalf, but the thought that as a superintendent, I want the ability to negotiate this. And it might not come to fruition. I might not be successful in those negotiations. That's part of the nature of negotiations, and that's fair game. But I want to have it as a bargaining chip because I want to be able to subject school employees who are covered by the union so that I make sure that they are in fact safe. for lack of a better term. And again, I'm stepping outside of my role here, but I can imagine from a superintendent's position, give me the tools to ensure that these children are safe. Give me that tool, or at least give me the opportunity to negotiate for it. And I think that is what is being asked. But again, I put a big asterisk by that testimony because I'm not a superintendent. I'm not a lobbyist. I was asked to draft this. I drafted it, and here we are having a great time talking about it. But I think that's really the decision this legislative committee has to consider. I think it is being asked as a tool. I don't think it's being used to target any one individual, and I would be very remiss if it was used in that way.
Can I have one last? Thank you. So is your impression that this is, you talk about proactive. Is this really proactive? If it were proactive, would it not come from the Superintendent's Association, the School Boards Association, and the various associations are representing educators out in the field? But this is not. This is coming from an individual.
I think that is a very fair concern to bring up. Again, I can't speak for those other groups. I don't know who has vetted this legislation in terms of those other organizations, and they're certainly free to attend these hearings and speak as to their position on this bill. I'm not in a position to say that.
Further questions for Attorney Fenton? Seeing none, thank you very much.
That's it.
Yeah, well, we've got more bills, so stick around.
Thank you very much.
Any other conversation with the subcommittee? I think, yes.
Yeah, I just have a comment, Chairman Ladd. I think our duty as legislators is to listen to constituents and not just union representation. And we had a constituent who also happens to be a superintendent bring this legislation forward. So I didn't necessarily think he was being reactive. I thought he was being proactive in trying to prevent future situations like this from occurring.
Sure.
Our responsibility here as an education committee, we represent education in the state of New Hampshire, not necessarily in one specific district. And it's important that when we enact legislation that's apropos or applicable to all districts and have intent and rationale behind why we're doing it. I'm not negating what's going on, particularly in Goffstown, but there's a process which we have to follow, but also that the superintendent should be following and working collectively together. They bring forward, and so does the School Boards Association, recommended policies which they're working towards in any given year. They share that with us, and then we go forward. If we react to every singular issue that comes, our statutes are going to be much, much larger than what we necessarily see. You know, we see the green book that Representative Tanner was wanting to see every year. We're going to have to be carrying around, a cart pulling all this stuff. So I'm concerned that we enact legislation that is really necessary, and rather than creating something here, which this is going to lead to another piece of legislation because it's going to be applicable only to certain districts. So it's lining up for more legislation. In fact, let's do it right when we initially do it. Thank you.
Follow up?
Follow up?
Yes.
I do agree with that. I don't necessarily think that this is the particular vehicle with which to, but I think it did open up an area which does need some attention paid to it. And so I would thank that superintendent for bringing this forward because it did bring this discussion to our attention.
I can respond to that too. As an administrator, I've been in situations like this. However, this issue is a broad issue, targeted or for whole groups, one district versus another district, whether you have a union or not. There are just too many loose ends here. There is something behind it, yes, that's maybe we need to be looking at and working collectively with a broader range of folks to get something done that's going to be more lasting in nature.
President Damon?
Thank you. I think I have three thoughts. One is it keeps sticking in my head Attorney Fenton's observation that this statute has changed a lot since 10 years ago. And it has raised my concern that in fact we might not know the background of people who were hired long enough ago that the current criminal records checks didn't apply to them. So that, I think, is something to perhaps, as Chair Ladd said, consider in what legislation might look like. I mean, I think we could amend this bill to include the broader array that has been referred to, not just the public schools. And I've now forgotten my third piece. Oops. I'll stop there until it comes back.
Okay.
Thank you.
Thank you. I think that before November 13th, it is our full committee meeting. As you've got your third point,
I did.
go ahead.
It seems that we could ask the professional associations that we don't know what they think. We could ask them to tell us what they think.
Thank you. I think there can be, between now and the 13th, additional looking at this language and possibly other language to address some of the concerns. But I also think that it has raised an issue. Representative Damon, you just mentioned one in terms of the length of time after that initial employment check. And the fact that without statutory language, even if a district did negotiate further background checks, they could not get the full set of information because it's not in statute. So I think that's, for me, that's an important point also. And, we'll try and find some time to, play around with the language a little bit myself, and hopefully others might also, if they think that it's worthwhile. Anything?
Well, I just think that there's none of our associations and none of those folks which are not in associations that don't all want safety in our schools. And to have, folks in our schools which are appropriate to be around children. I think we all agree on that. So I think this is something we shouldn't let go, but you're right, Representative Cordelli. It does, maybe something can be crafted. However, if we do so, I think we have to do it with support of all people that are coming in contact with these children.
Okay, thank you. I guess with that, we'll close on this bill 267 for today, and we'll be revisiting it. And we have another bill to address during this set of bills, and that is House Bill 628, which requires certain non-public schools or educational service providers that accept public funds to perform background checks on all employees and volunteers. I think Representative Myler, you had something you wanted to pass out, and I do as well. And some more from me. Sure, we can take a few minutes to, yes. So we'll take a few minutes breaks anyway in between, 5 minutes, and we can look over this material. Okay, sure. Do you want to start?
Yeah, unfortunately, Representative Hamel is down with a very difficult cold at this point in time. So she's unable to be here. The intent of her amendment to her bill is to eliminate any thought that homeschool parents would not have to go through a background check. That's basically what she was trying to do with this amendment.
Thank you. And what I passed out, information from several organizations in terms of their background check policy. One is from Prenda. There is another from David Tebow, who is the chair of the Non-Public Schools Advisory Council. And the third is from a previous bill, but on the same topic, from the Diocese of Manchester, in regards to their policies. So we can take a few minutes. There are a few more copies up there. Right. This is the second 9 o'clock.
So.
Yeah, that's okay. Yeah.
Okay. Okay.
Are we okay to, everyone had enough time to read through these materials? Okay, we'll give it a couple more minutes. Bless you. Everybody good to go? Great. Um, Shall we, Representative Myler, do you want to talk about the amendment first? Right.
Covered here, I know that Linda indicated to me over the phone that.
Yeah.
That homeschool parents would not be involved in this. But that others who are receiving public funds would be covered under this, her amendment.
So that's the section 3.
Yeah. Because that was a major concern, I think, when we talked about it before. She heard that and wanted to make sure that it was clear that she thinks that this would deal with that.
Yes. Representative?
So I just want to make sure I'm in section 3D where it says this section shall not pertain to a parent giving a non-EFA home education program to their children. So basically what this is making clear is a parent is not going to be having to get a criminal background check to educate their own children. But what about these situations in which parents informally come together? So, which I am becoming more and more familiar with, and where a neighbor is better with math, and so they get together in this sort of an informal pod. I don't know if that's the correct word. Would those parents be required to have a background check? What I'm becoming more and more familiar with is this idea that You know, I used to think homeschooling was a parent just teaching their kids, and what I've learned is that it's a lot different than that. So just some, I don't know if you can give it because it's not your amendment, but I don't want, that's what I take issue with most with this bill, is the burden it puts on parents who other parents know well, they have a relationship with, they trust, and they will be subject to criminal background checks. So I don't know if this language doesn't address that. It just says a parent doesn't have to, with their own children, doesn't need a background check, which, I mean, obviously that should be the case. I just want to bring that up, and if anyone can offer clarification.
Representative Myler, or?
Yeah, I can take it. And I think in sections 1 and sections 2, which address the conditions that would require a criminal history records check, would not apply in the cases you just mentioned, because it doesn't talk about home schooling. It talks about specific programs, the Learn Everywhere program, the Education Freedom Accounts program, or another funded program through a scholarship organization. So that would be like a tax credit. So I think in the situation where you've got a neighbor who's coming over to teach a homeschooled child music or art or something like that, neither in section 1 or section 2 does it appear to apply to that person.
If I could mention on that same section, section 3D, the last sentence, this section shall not pertain to a parent giving a non-EFA home education program to their children. But we do have homeschool parents with EFA accounts. So they would be subject to the background check.
But those aren't homeschool kids. Those are EFA kids. We've heard that from the commissioner, that those aren't considered homeschool. Those are considered EFA students.
But I don't think that's clear in this section. The way I read it is that if a parent is giving a non-EFA home education program to the children there, they don't have to submit the records check. But a parent who is giving a program to their children with an EFA account, they do have to qualify or submit the background check. Representative Ladd.
There are 4 ways that in our state of New Hampshire that compulsory attendance can be accomplished. 1, homeschooling, EFA, public, and private. Those are the 4 links. There is a difference between EFA and homeschooling. They are separate programs. If you receive an EFA, you're part and recorded as an EFA student. So I think that should clarify that. But I have a problem on line 19, where it's talking about the Children's Scholarship Organization funded programs. Is this talking about the education tax credit? If so, those are not government monies. Those are monies which are tax credit monies from business. And they don't go to the state. We've had this discussion over and over and over. And so I don't want to see any linkage for this program applying to students which are receiving solely the education tax credit.
So let me would it be acceptable to you if we took out from the end of line 19 or our Children's Scholarship Organization funded programs, take out that part and basically just leave Learn Everywhere and EFA program.
I think Representative Luna, that is a concern that needs to be struck from this bill, should it move forward. My overarching concern here is that we have a number of private, number of private schools in this state, which we have students that are tuition to. And they could be anything from a Holderness Kimball Union to, those are private schools. But they could receive tuition students based upon the way we have the tuition program set up. I'm concerned that we got to be very careful in over-regulating private schools. If we do so, we're going to lose that opportunity for them to receive tuition students. They're going to say, it's not worth 1 or 2 or 3 students, but every student's important. So I'm real concerned that we not encroach into private schools that are separate from public. They're functioning basically, yes, they do receive some tuition programs, but I think we got to be very careful.
If I could just mention in regard to that, the handouts that I provided, one of which is from Prenda with their background check policy, which includes an annual background check for their instructors. And also from the chair of the non-public school advisory council, who really echoes the same thing that the previous chair echoed back in 1999 2019 to prior legislation, that if you're accredited by NIASC, you have to perform background checks. And every school in New Hampshire approved for attendance by the state, part of the process to get approved is that you are going to be performing background checks. So I think that I'll also mention, as was pointed out in one of these, that these policies go further than the public school policy, and the public school policies just require background checks for designated volunteers, where these do not have that restriction, and volunteers generally are required to have background checks. Representative Luna?
Thanks very much. I mean, as we heard, public school policies require criminal history background checks. The national FBI criminal history background check for any prospective new hire. So I would not say that the example given here in Prenda goes beyond what our public schools are doing, and I think even more concerning to me, in reading the Prenda background check policy, is it seems to conflict with what we just heard on the last bill, and I was wondering maybe if Attorney Fenton might be able to come up and particularly address some of the points that Prenda is talking about here, and whether or not that is actually even possible to happen, because we know Prenda operates here in the state of New Hampshire. We know they have employees who are called guides. We know they have volunteers, and we have them saying that they do a federal criminal search and a national criminal search. Yet we've heard that the superintendent in Goffstown can't get that information. So I'm not quite sure why Prenda can get that information, working with public school kids and non-public school kids, and a superintendent can't get that information. It appears to be in conflict.
Would you like to offer anything in that regard, Attorney Fenton?
So the question would be, would Prenda, through a third party private company, and they call it Checker, be able to conduct the federal criminal search, they call it here, and a national criminal search? Would they be able to conduct those, and do those searches, are those searches equivalent to what the state of New Hampshire requires for public schools prior to hiring an employee today?
Thank you for the question. For the record, my name is Diana Fenton. I'm with the Department of Education. It would be the Department of Safety who could best answer this question. So with that caveat in place, my understanding of the system is the federal background check does not get disseminated to non-governmental entities. You referenced a third-party background check company. Those are very common. Again, my limited understanding is those third-party private vendors, because that's what that is. It's a private vendor, does not have access to the FBI background check. They will do computer searches. They'll check public records, things of that nature. There could be an exception through the Adam Walsh Act by which they are getting that information, that federal background check, but I don't know that for sure. Again, this is my cursory understanding of that system of criminal history checks.
If I could just point out the letter from Shauna Knutson, who works for Prenda nationally, that they comply with 189.13a 5, which I think are the
Disqualifying offenses.
right. Yes, thank you.
Can I ask
Sure.
a question? Diana, if I'm a school district and I contract with an agency, let's say to provide the services that we're looking for, whether it be speech or some other area, does the agency, is that the organization which does the criminal background check? Or how's this occurred? The individual that comes out to do this may not necessarily be a speech pathologist. It may be somebody doing the job under the supervision of somebody within that agency. How do we know that that individual coming to have one-on-one with a student has a criminal background check?
My understanding is it is a function of the school district. It will be the school district that will take on that role and run that background check and review it.
So if a school district's contracting with the agency to provide that, and Mrs. Jones shows up today and maybe Mr. Smith the next day, they have no idea who is coming. So how do we ensure that there's criminal background checks? Is it the agency that's given that check as an individual?
So again, and Representative Cascadon might have personal experience with this, given her prior role as a superintendent. I will change your fact pattern briefly, and if you take it more broad-based, custodial services. Those background checks are performed by the school district employing those individuals. If you look at it as more of those one-on-one services, it has been problematic for the school district to be able to conduct those background checks because, as you said, it might be a shifting,
Changes, yes.
changing nature. Those are very fact-dependent situations, and they are handled on a case-by-case basis by the school district. I have spoken to superintendents who have grappled with that from time to time, figuring out how best to ensure the safety and comply with the law. But in large part, my understanding is those private entities
do not have that access, and the school district does.
Thank you.
Representative Luna.
Thank you very much, Mr. Chair. Going back to Prenda, what's the department's position on public schools using Prenda pods to I guess in-person instruction with a public school student? I guess it's two parts of the question. What's the department's position in public schools contracting with Prenda to provide in-person instruction? And then number two, what is the department's position with respect to criminal history records checks on Prenda employees and volunteers that provide in-person instruction?
I don't know if I'm able to speak on our position. I can answer technical questions. I don't know if I'm here to speak as to broad-based policy initiatives.
Well, so I'll turn it into a technical question then, as opposed to a policy initiative. If the Hopkins School District was to contract with Prenda for a Prenda pod that used both employee guides and volunteers to provide in-person instruction, what would the Hopkinton School Board's responsibility be insofar as a criminal history check on these those personnel?
I would have to look at that contract. I don't know the interplay. I do know that for all the initiatives the department undertakes, we do so keeping in mind that criminal history check is paramount, but I can look into that interplay and get back to you. I just don't have that
Okay,
information.
thanks. And that I think would be a big help. And I think, the question we're putting for that I just, put out here, I think is very similar to what Rick just put out with respect to, a contracted occupational therapist service and that a school may contract with. You're not quite sure who you're going to get for personnel on any given day, but what's the school board's responsibility as far as criminal history check on these personnel who are providing in-person instruction to public school students?
Representative Damon.
Thank you. I have three things again. Maybe I'll remember all three. So just to clarify, Representative Cordelli, on your remark before we brought Attorney Fenton forward, the amendment proposed to the bill does specify designated volunteer. The original bill didn't say designated, but the amendment does.
Yep. Right.
Sorry, so it is specific to designated volunteer, not in the amendment. My question to Attorney Fenton, my screen just closed. I'm on Checker's website, the company that the Prenda materials indicate they use. And in part, it references doing their federal criminal records check through PACER, which I'm not familiar with, the public access to court electronic records. Can you comment on what's available through that? Similar to the questions that have been asked about in our discussion of the prior bill, information not being just readily available to individuals. Is this different from that?
So I just typed in Pacer as well. I've never explored this website. You've given me something to do this afternoon. So thank you very much. My understanding is court is an open forum. Anyone can walk into any courthouse and listen to the docket. And these are public documents. People don't think of them as public documents, but if you go into court, you can watch a trial, you can hear a case and you can hear what the verdict is. You can find out if someone's guilty. This is why we watch WMUR in the morning and eagerly await where Ray Brewer is in the morning before a courthouse. It is public information. It is a public record. I think what these private companies such as Pacer do, and again, I have limited information, but this is my understanding, is they can look up Diana Fenton and individually say, in the state of New Hampshire, has she been convicted of something? In Nevada, has she been convicted of something? And they go through and it's just a constant computer search. Whereas Pivot, you can get all that information, or Pivot and you go to the federal background check and it's all given to you on one paper, right? And so the information is all obtainable. It's just how do you obtain it? It's not that it's private, it's not that it's confidential, it's just there's one entity that compiles it as part of their administrative obligation, and then they can disseminate it, or I sit here and I type in Hope Damon in all these different capacities, and I pull and compile the same information. I think that's what you're finding. That's what the third-party vendor does.
Follow?
So if I'm understanding you correctly, in theory, Checker or other companies like them through Pacer could come up with all the information that would be in the FBI record, but they would need to be very diligent and thorough to do that.
I agree with that statement, yes.
Thank you.
Representative Petronell, I'm sorry, did you have
Sorry, the
follow-up?
last piece I had is I just wanted to make the observation that regardless of whether we agree or disagree with the adequacy of the Prenda process, Prenda is by no means the only micropod, correct terminology if possible, option that is available in New Hampshire. So when we look at what we might do with this bill, even if we think what Prenda is doing is fine and adequate, it doesn't cover that whole population of people involved with students.
Representative Petronell?
If we really want to open up a can of worms in both of these pieces of legislation, if you look further down the page on Checker, they have continuous criminal background checks. So you can be alerted anytime there's a reportable offense from your active workforce.
Thank you.
Maybe this should wait.
Yeah, did you? Okay, any further questions for Attorney Fenton? See none, thank you very much. Great, have fun. Save you some work this afternoon. Do it now. Yes, Representative.
It just seems to me that in order for these schools to remain in business, they have to provide a level of criminal background checks that will maintain the parents' trust. Case in point, well, what Representative Petronell just mentioned about that organization, but just to draw your attention to the Diocese of Manchester, Robert Dunn, and the final paragraph of that letter says that the Diocese of Manchester has a robust criminal background check process in place for its school employees and volunteers. He goes into the details and then says, the Diocese of Manchester has instituted these procedures even without the mandate that HB 1664 would impose. We don't need this law. These schools have to do this in order to stay in business. And I know from personal experience, the Catholic schools went through a rough time. Enrollment plummeted. In order to regain the trust of parents, they had to institute impeccable standards of background checks, and they have regained that trust greatly.
I just gotta stop you right there.
Well, let her finish.
The Catholic schools went through a tough time. How about their students that were abused?
Well,
Did they
public-
go through a tough time
let's
too?
calm down.
Say that this is, the poor Catholic schools. I mean, this is,
It happens.
this comment right here is just laughable.
It happens in public schools too, so let's not go there.
This is.
What do you mean it's laughable?
I kind of object to this.
Yeah,
I'm
let's
trying to
let's take a
speak.
step back.
Okay.
Would you like
I'm
to
speaking
continue,
from my
Representative?
own experience, having had a lot of experience with Catholic schools as a parent, having to go through all the hoops and all the watching videos and the fingerprints and the background checks. My point is, I'm just using it as an example, as Prem does, in order for these private schools to maintain their enrollment, to have parents trust, they have to do this. They just for that reason, and in so doing, and they do this without a mandate of a government overreaching with more regulations.
Representative Pettinel?
I have to agree with Representative Cortiello because I went through this also, and the silver lining in that scandal that the Catholic Church went through had repercussions, making everybody aware of sexual abuse that can occur, any abuse that can occur. And I routinely go through training, even though I'm not a teacher, to stay safe, having interactions with youth. And I've gone through multiple trainings as a coach, as a stroke and turn judge for swim teams, as a soccer parent. And I've seen people, regardless of background checks, regardless of training, still behave as if the rules don't apply to them. And if anything, the other letter that we received from Mr. Tybalt from the diocese emphasizes parents being educated. And I think that would be the most important takeaway from any of this legislation, is that parents seek the education they need to look for these behaviors that they should be alerted to so that they can keep their children safe. Because regardless of the background checks, regardless of as much safety we put educators, volunteers, anybody through, there are still criminals who will behave in ways that supersede the rules.
And as we've seen, a background check is a snapshot in time. You know, you can have a background check today, but what happens on Friday, is something different. I thought I saw someone else with a hand up. Yes, Representative Damon.
Thank you. So, I don't understand, and I would like to understand, if in fact the Catholic schools and various other entities that are being referenced are already so completely thorough in their background checks, then why would there be an objection to what this bill says, because they would already be doing it?
Representative Pettinel.
That's a very good question, because we just heard a bill where the public schools have objection to further background checks. I'm seeing evidence, and you said Prendel wasn't the only example, but I did see that Acton Academy, in order to maintain your status as an Acton Academy, you need to perform background checks every 4 years on your educators in that system. We have 2 Acton Academies in New Hampshire. My question, and kind of a rebuttal to your statement, is there any specific situation or an example of a situation that makes this legislation necessary? The last bill that we heard, there was a specific situation that was brought forward. This one, I'm not seeing a specific situation. I'm not seeing a specific organization that is having concerns, other than legislators who seem to think it's necessary to attack recipients of education freedom accounts or non-public schools. And quite honestly, as a former homeschooler, I see this as an attack by the public education system on families that they want more information from than they are receiving.
I would hope that we could find a way to so prioritize the safety of all children, regardless of the environment in which they receive education, that no one would perceive this as an attack. And I come at this as a victim. So it deeply, deeply troubles me that we would put barriers in the path of doing the best that we can to assure that people who are interacting with our children have no criminal record history. And yes, something could happen tomorrow. That's absolutely true in any context. The majority of perpetrators of harm to children are known to their families. Wonderful, responsible, well-informed parents don't always see it. This is just a piece, I think both of these bills actually, to try to increase the level of safety. Will never be perfect, but it's not an attack. At least that's not at all how I perceive it.
I would just say, I think that I see it more of an attack myself. And I don't think that, as we've seen with the documents about background check policies from various organizations, I think Representative Pettingill, you mentioned it, they're doing it without a government mandate. They're doing it because of their concern for safety. And I think it also leads back to the last bill and doing something so that background checks are not performed once in a teacher's or educator's career, and that's it. Yes, you got to.
Thank you. So, if the bill currently before us is an attack, which for me, it totally is not. But if it is, then the prior bill is also an attack to a different population. I mean, I don't think we can have it both ways. We can either say both bills endeavor to create a better safety net for children, or we can say they're both attacks or they're overreach, or for whatever reason we don't support them. I mean, it seems to me it shouldn't matter what context a student is being educated in, that they be safe. They need to be safe no matter what.
I don't think we can, as legislators or parents or anything else, guarantee safety. Go to the playground, play at the neighbor's house, and we just have to hope that and pray that they are always safe. But I just wanted to raise one other question on the amendment. On line 11, it requires submission of the background check, but submission to who? So non-public schools are going to be required to do background checks and then submit them to the Department of Education, or submit them to who?
So, as described under RSA 18913A, so it may be addressed in that. I'm not an expert on this bill, Glenn, but it may be addressed in that. I was also wondering if it might be a benefit to the committee to maybe get a representative from the Department of Safety in here, because Glenn, you just said, things like, well, Prenda is doing it and others are doing it, and it would really be good to understand what it is here, because the state of New Hampshire requires employees that are working with our public school students to have an FBI criminal records check prior to employment. And if that's the standard, we should understand if the products that are listed here by Prenda and possibly by others are equivalent to that, or the same as that, or somehow different than that, so that we can sort of compare apples, whether we're talking about apples to apples here. And I think Ms. Fenton has done a tremendous job to try to provide some advice to this committee with respect to how robust these various criminal records checks are. But when we go from the statute and what we've heard in testimony before, and then we go to the Prenda letter, we're seeing different terms here. We're seeing terms like federal criminal search and a national criminal search. Whether that's the same as an FBI criminal history records check, I don't know. And maybe there's somebody from the Department of Safety that can help advise this committee on what the FBI does and what some of the third parties like Checker and others that have been discussed, what products they provide and what level of safety or at least what level of assurance they're providing the entities that are requesting these history checks.
Thank you. Representative Ladd?
Thank you very much, Mr. Chair. I think we've got to be very careful. We're not going to compare what we're doing right here in 628 to what we were just looking at in 267. We're talking about separate areas of statutory language. In the one we just dealt with, 267, we're talking about 189.13a 1A. If you were to look at that statutory language in 1B, which we haven't even focused on, it specifically says a non-public school may elect to require a criminal records check on selected employees. So 1B talks to the non-publics. This we have right here in 628 is also talking about non-publics. So there's another area of statute says they may elect to do this. Now they were saying right here in this, which we're not changing 1B at all, that it's going to be required.
Well, only for non-public.
That's right. Non-publics.
Only the ones that participate.
Yeah, I'd be very careful there because, when you start involving non-publics, there's a reason why we had the may there before, regardless of where, the students which are being tuitioned to them, whether it be through a tuition program or through an EFA program of some sort.
Yes, Representative.
I feel the need to make this comment. It seems to me that in this committee, we are often talking about issues where we agree on the what. I'm thinking mental health. I'm thinking school lunch, feeding children not going hungry. Here's another one, safety of children. I care deeply about those poor children who suffered during that crisis, okay? I didn't mean to downplay it by not mentioning, what we seem to always disagree on is the how, and often that how regards government overreach. You may call it an attack. I'll be more subtle, call it government overreach is what this is about. And the difference between these two bills is that the previous one was about public schools. Okay, I don't think the government can overreach in their own schools, but this one's about private schools. So that's what I take issue with.
So just and I appreciate your comments, Arlene, and I apologize for my earlier interruption. So, but what you just were suggesting reminded me of a bill that was passed earlier this year that would allow a public school board to contract with a private school to provide educational program for all of its students. And in that case, what are the obligations? And maybe this is another Attorney Fenton question. What are the obligations that the local school board, the contracting school board, has in terms of assuring assuring the safety of their public school students in an environment where the employees of that private school have undergone FBI criminal history checks the same way an employee of a direct employee of a public school so does that apply to the contract, to a public school district that contracts with a private school for educational services? Does that private school have to comply with the same FBI? It's really related to the one we're talking about right now, 628, which is specific to non-public schools that are providing services under Learn Everywhere and EFAs. But if the argument goes that non-public schools should not be mandated to require criminal history checks on employees, does that also apply to when a non-public school is contracted by a school district to provide all educational services for their students? Well, we have a bill that yeah, I mean, there's a bill that says that that a school board can approve a non-public school for under tuition agreement to provide services for its students. So what does that non-public school have as far as FBI criminal history check requirements on their staff?
Very complicated area.
Yeah, yeah.
Right.
And I thought a couple of years ago, Rick, that eDNA was doing was there a study committee on criminal history?
Whether it was SB 8 at the time or not, but we underneath the school tuitioning program, where the local school board makes the decision where the kids are going to go to, they have to, they approve, the local board approves that receiving school based upon certain identified requirements that are in that language. I'd have to go back, but I know the health and safety are all part of that.
Can't shirk your obligation to special education. The local school district is still responsible
Yes.
for providing.
Yeah, oh yes, that's the
ID,
sending school
yeah.
is still responsible for that. But the receiving school, which may be a school like Thetford Academy, which is in Vermont, which is taking kids from all over this side of the Connecticut River. They may not provide all those services, but they meet whatever the local board has set up, and I think they do meet those standards because they're a pretty well-established school. We'd have to look at the statute, to see specifically what it says.
Right.
Yeah.
I think maybe that's heading in a different direction than our focus right now. And we're a little bit behind a schedule with our next two bills. So if there are any final comments?
Let me just, I think, I want to respond to the issue of overreach. I think one of the concerns here is that as we begin to expend public monies to other entities, it is the responsibility of this committee and of this legislature to ensure that those public monies have the appropriate oversight. And this happens to be, we can all agree on the issue of student safety, but I think it's not like you've still got these private entities out there that are operating independently. Once they begin to receive public monies, taxpayer monies, then it is the legislature's responsibility to make sure that the appropriate oversight is there. And I think that is really I can't speak for Representative Tanner, but I think that's the intent here, is that when you have public monies going into these various programs, that there needs to be some oversight, some entity that's looking out to make sure that the taxpayers are in fact getting that kind of oversight that's needed. That's I think what the intent is here.
Thank you. Given the time, and we have some members of the next subcommittee who have been sitting, waiting for a little while, why don't you come forward and we will take up our next two bills. The first of which is House Bill 623, establishing a teacher loan forgiveness program.
Much greater feeling for people sitting on this side of the face. And looking across, it is blinding.
Yeah.
Oh,
It is absolutely. I know we could not use
Okay. What's the bill first here?
623.
$623.
Right. And with 623, we had the original bill and then an amendment put forward by Representative Myler, 0221H.
And I'm ready to speak to.
Great. You're up.
All right.
Oh, okay, just 1 minute for,
Water break.
oops, thanks. This is a new one. Just get some water or whatever.
Oh, no. Yeah, yeah.
Yeah, you got a couple here. 218, 217 is over there in the Senate, and 623 with.
Right.
Of all those bills, I like the one in the Senate. You signed on to that,
Did I?
217.
Oh,
Where it came from Idaho.
oh, oh, thank you.
A little tweaking that one could. I noticed that you were a standout all alone.
Yeah.
But you know, it's that comes from Idaho, and it had a lot of, I would say 90% of Idaho's language, and what they did was fairly solid.
Huh. I didn't even realize that.
Mix, but
Yeah, I don't know either. No, I think I remember seeing that and saying, how did I get on that one?
well, you're on it.
Yeah.
Yeah.
So why I'm doing this.
I'm not really on the committee. I'm just sitting here.
You're there, so you're there.
Yeah.
That was the basketball season officer.
Oh, yeah. Basketball season practice. First practice was what today's Tuesday? Yesterday.
He's a junior this year.
He's a junior. Yeah. He came home to visit last week.
How much is he grown?
Oh, he's now at 7 foot, actually, a little over that. And he came home to visit. He lasted one night. It was so hectic around the house. He said, I can go back to college. So he's back there.
Those little guys running around.
Oh, yeah, little 5-year-old running around nuts. And actually, not nuts, just, always wanting attention. Of course, that's the nature of a 5-year-old. Down.
We're doing reading today.
Tomorrow morning,
Meetings tomorrow.
9:30. Yeah. Is the coffee machine working? Coffee machine's working? If you press the button. This is for tomorrow.
What's that?
I think maybe we're finally ready to begin this set of bills. Apologize for the delayed start. We got into a little bit of a lengthy conversation with the previous ones. But this first bill is 218. And Representative Myler, I think you just handed out an amendment.
No, mine is for 620.
Oh, 623, right. Yeah, I'm sorry, that's what we're doing, 623.
All right, so here's where we are with this baby. When we left the last session, I did take this bill to our teacher shortage committee and did pass it out, seeking some of their input. Frankly, I didn't get much, but I did get an opportunity to work with Steve Appleby on this. When we left this conversation last time, there were 5 areas of concern. One area was that that this should be a state program administered by the DOE and not obligating local school districts to have to budget for this. That was one area. Second was an area of whether or not this could be retroactive to other to employees that would qualify under that 1 to 5 year stipulation. The third area that we talked about was, should we include in the bill Also, shortage of teachers in special education, math, and science. The fourth area that we talked about was that it should be more than just university graduates from the university system. The fifth area was kind of the definition of the teacher shortage. So what we've done in this amendment is that we have made this a state program. The sixth area was, of course, the cost of the program. So what we've done in this amendment, we've made this a basically department program to be administered by the department. In thinking about the issue of having it retro, OLS said that that's a very difficult kind of language to put in to make it retro, rather that it should be more prospective rather than retrospective. Then we looked at the issue of whether or not we should include shortages in special ed teachers and administrators, math and science. And I talked with Appleby about this at length, and we both came to the conclusion, no, that this should be a program that basically deals with, as it's intended, is to deal with the rural and those school districts that are underperforming schools. So we did not include that in here. We also then excluded the issue of only university students, and that it would be any new teacher that would be going into a school district. Then the other area deals with the financing of this, and I learned recently that the current fund balance of the Education Trust Fund is $220 million that's sitting there. So the 1 million and the 2 million respectively that are mentioned in the bill should be able to have ample funding from the trust fund. And then we also updated the dates that this would be appropriate. You also will note on the third page, line 3, there's an indicator that including the cost of administering by the department. In talking with Mr. Appleby, he didn't think it was going to take a lot to do this, but he said he'd like to have at least some note that if he had to have an employee that would work, 20% of the time or something, that it would be covered by the appropriation. So those were the changes that we made, and that's where we stand with this right now. Mr. Chair.
Thank you. Comments or questions for the Representative Cascadden?
Thank you. I'm trying to figure out what would identify a rural school, and I think it's 20 enrolled students per square mile. So can the department kind of come up with a list of schools based on that criteria?
That was their criteria.
Okay.
So they've got definitions. I didn't put obviously in the bill, but they have definitions for both rural and those underperforming schools.
Just one more question. UNH had done a rural school program.
Mm-hmm.
I don't know if that's still operating, or was it just a 5-year grant project, do you know?
I don't know the status of that, no, but I am aware of that program, yes.
Because it was very successful. If the state could do something very similar, which it sounds like this
Would do that.
does some of that, yeah. Coupled with a mentor program, obviously. Okay.
Further questions for Representative Myler, or comments generally on the proposed amendment? I do have one question. The appropriation of $1 million for 25 and $2 million for 26, those are caps to the program, so that if there are, more new teachers, let's say.
I do believe somewhere in here that the governor is authorized to draw more.
Okay, yes, I see it on page 3.
And in all candor, The million and 2 million is a shot in the dark. I
Right.
have no idea what that would be. That was just
Right,
an
yep,
estimate.
yep.
I do know that, as Representative Ladd said earlier, there is a very similar bill pending in the Senate in 217. So I want to make sure that we have, both bills may come into, if this were to pass, would come into some kind of a conference committee to look at whatever the differences are of the bills.
217 is a retained bill in the Senate as well.
Correct, yes, yeah.
Representative Cascadden?
So this loan repayment would apply to a first-year teacher going into a rural district?
Yes.
Okay, is there any commitment for them to stay so many years within that district, or does it matter?
We talked about that.
Yeah.
We talked about, if you go from one school in the district to another school in the same district. We just want to get this moving to try to have some incentive for people to be in these rural and underserved schools, yeah.
Representative Land?
Yeah, thank you. I had a good telephone conversation with Brian, sitting here with us today, just last night, or it was yesterday afternoon, somewhere along the way, Brian, that this, we have a number of bills right here coming for us. We have 623, 218, and 217, which is in the Senate. 217 then, in my discussion with Mr. Hawkins, was that it kind of echoes legislation that was recently passed by the state of Idaho. And there is a very similar bill which they passed. They used much of the same language, which you're seeing here, including the amount of money to be awarded over the first, second, third, fourth years. They also addressed rural isolation of schools pursuant to what they identify as rural out in Idaho. Of course, their definition is going to be a little bit different than what we have here, because they really do have some rural areas out there. But they also have monies going towards economic disadvantaged school based on eligibilities that receive Title I monies. So that would bring in our case, Manchester, and those schools which are economically hurting. So it's just not just rural. It's rural in underserved educators and districts which are hampered by the economic situation within those communities and the federal dollars which they receive. So I would really, because the whole concept, what Idaho did is very positive. And that's reflected in 217 and to a degree in 218 as well. All this language is kind of coming together. So I'd encourage us to, I had a good conversation with Brian on that. He also forwarded to me the information that came from Idaho with their legislation and how it's working. Seems to be a real good program. So I think maybe there's room here for merging these things into something that we have. Sure, yeah. And we discuss this again tomorrow at 1:00 with the teacher shortage committee. And we're just finishing that up. But I know that this will be a point of discussion there as well.
Representative Cascadden?
Thank you. I don't know if this addresses it on line 4. It does have part B. This is on page 2. Economic disadvantage of the school based on eligibility for funds pursuant to Title I, Part A of the Elementary and Secondary Education Act. I don't know if that's what you were talking about, but that would be included here from what I understand.
Representative Damon?
Thank you. On the same topic, Chair Ladd actually spoke to what I was thinking about, that Manchester, Claremont, probably some other communities wouldn't qualify as rural based on the definition in first page line 23, 24. So I keep wondering if this shouldn't be rural or underperforming school education program, or. So in other words, you'd be eligible if you taught in either the rural district, the underperforming, or both. I look at Claremont and Newport as desperately needing this to help with retention, but I don't think they qualify as rural.
Representative Land?
I agree with the rural part of that and the or. but when we say or underperforming school district, I like the language that Idaho has even more. And it reads specifically, economic disadvantage of the school based on eligibility for funds pursuant to Title I, Part A, Federal Elementary and Secondary Education Act as amended. So it's the economic money flowing to it, and that's that economic base. It's not necessarily underperforming, which might be, well, you're not performing well with your achievement scores. And I don't think we should be basing on that. I think it should be based on this other target, which Idaho put in place.
I think maybe that language from Idaho is what you were referring to, Representative Damon, in terms of economic disadvantage on Roman 2B. So I think if anything, Roman 6, where it says rural and underperforming school educator, it really should refer to Roman 2, which has 3 criteria rather than just those 2.
Yes, I think that's correct.
Further,
No. Are you good with that too?
Sure.
okay.
May I?
Yes, go ahead.
If I may, my concern is I don't know what's going to happen to 217 in the Senate. All right. And so I think by having two bills moving in a concurrent fashion, I have greater hope for the House because I don't know what's going to happen in the Senate. So
It's always a crapshoot over in the Senate.
yeah,
isn't
it is, and so my sense is if something were to possibly happen in the Senate, obviously it's going to come over to here again. We're going to see it here, but I just think we've not been able to get much as a result of the teacher shortage committee before the House. And so that was why even though I knew that 217 was moving through it, I just thought we should have another one over here too, as a complement.
Right.
They complement one another.
Right.
That's it.
Yeah. And I would just offer, if there are any senators tuning in, my apologies for that prior comment about a crapshoot.
Representative Cordelli?
Yes.
I would suggest that we have a side-by-side made here between 217 and 263. Of course, we have 218.
623.
Pardon me?
623.
623, excuse me. 623 doesn't really specify all the things that 218 does, or 217, because 217 and 218 are verbiage is very, very close. And looking at 263, are these 3 bills all for the same intent, the same purpose?
Yeah.
Yeah.
Yes, I think it is.
Yeah. Because when I look at 217 and 218 and Idaho, the numbers are the same. Roman 7 is on 2623. Those are the same numbers that appear in the others. 1,500, 2,500, 3,500, 4,500. The $1 million, $2 million, same thing as we see in all these bills. So I think there's a possibility here we could be able to use one of these bills as coming from the House and parallel it with 217, and I think we have a better chance of getting something happen. I would suggest that we have Jennifer Ford work on a side-by-side for us.
Yeah, we can make that request.
Yeah.
Could I ask one question, Representative Myler, on your amendment to make sure I have my understanding correct in terms of the award, so that if a teacher, an educator goes into one of the schools that we're defining here, they could, and they stay for 4 years, they could get a total of, I think, $12,000.
That's correct.
Okay.
Yep.
And if they leave beforehand, they would just get whatever they've been, based on the number of years.
Correct.
Okay, thank
I
you.
mean, I think frankly, the intent here is, it's kind of an incentive that hopefully, if they're there for 3 or 4 years, they'll want to stay. I mean, that's what the intent is here, as well as to help them out too.
Sure. Representative Damon?
Thank you. I just wanted to add a perspective. Last night I was at a Goshen school board meeting. Goshen tuitions all their students to other schools, K to 12. And the main meeting was Newport School District, which receives a number of their students. They had 9 people presenting the various different programs in the Newport School District. And in the discussion, it came out that the entry-level salary in Newport for a bachelor's level teacher is $37,000 and change. You know, it just, I mean, we know how different the payment, the salaries are in different districts. But you can go 15 minutes down the road to Sunapee and get $15,000 to $20,000 more. So the need for this to address these economically poor districts is profound.
I would just comment, I think that we see that in many professions, in nursing, I know, for instance, with county nursing homes versus hospitals, et cetera. So, Representative Ladd.
Yeah, in my conversation the other evening too, there are some differences. 2 of the bills have 4 years, one has 5 years. But I'm looking right at the titles right now. And I think that we got to be very careful of the impact we may get from some people within our community. When we talk about forgiveness, you might have those saying, well, I just went to school and got a 2-year skilled training in an associate's degree. I'm not going to get any forgiveness on that skill. I paid my way. Whereas I look at the other 2 bills, one says as a title, establishing an early educator professional development grant, taking that word forgiveness out. The other one, 217, establishing a rural and underserved area educator incentive program for higher education and making appropriation thereof. Therefore, I think I just inclined to think that when we're talking about forgiveness, what are we going to be doing next for what other training and skills areas? Whereas we're recognizing there is a shortage in certain areas. We have problems in underserved economic service areas like Manchester with that shortage of science and math and special education, etc. I think that the whole thing is not necessarily the primary purpose for this is to get qualified people into the classroom to teach and to keep people there rather than jumping ship and going and working for ExxonMobil or some other outfit. So I'd rather not call this a forgiveness program. I'd rather address something more specific like 218 or 217.
Right, I believe, Representative Myler, in your amendment, you did change the title.
Well, it says incentive program. So,
I was looking at the original.
yeah.
The original title, which
Right.
It says early educator professional development on a summer on 218. 623 says
Incentive program.
It does say loan forgiveness program.
it said loan forgiveness program.
Right, but
on the initial.
Right.
right.
That's got to change.
Right, in 322, Amendment 2322, it looks like the title is replaced with establishing the rural and underperforming school educator incentive program and making an appropriation therefore.
That's echoing 217,
Yeah.
which I think is appropriate. Yeah.
Okay, well, we'll
Yes, Representative McDonald.
Thank you. I posed a similar question at our last meeting on this bill, but it still pertains to the amendment, specifically page 3, beginning on line 5, which is again the governor being authorized to draw a warrant for the additional sum out of any money in the treasury. Is that a typical practice to not have checked by the executive council, especially as written, to not have a limit on that? It says any money. Could that just be unlimited? And is that a mistake, or should that be addressed within this bill to put a cap there, perhaps?
Process.
Right.
The process for that is that any money it's going to have to go through fiscal. So there is a legislative step which oversees this process. So that's a committee, a joint committee of the Senate and the House. And then it's everything that goes before the governor and council goes through fiscal. So I think, and this is typically the way things are written when we're at the second year or a year in which we have already approved the budget. So we're looking, where can we go to find these monies? Whether through a federal grant, a state money might have something to DOE, or are we going to go back and dip into a trust fund of some kind?
And I believe that is in the Education Trust Fund, similar language, so that if there is not a surplus and there is money needed, the governor can just draw a warrant for the needed funds.
Good question.
Yeah.
Further questions on this bill, or, we'll see about a side-by-side and,
Well, I'll work on trying to maybe add another amendment that makes it even closer.
okay. Great, thank you.
When you talk about a side by side, you mean with 217 and 218?
Yeah, I really think that's where we need to go.
To really spread it out.
Yeah,
And-
I think we need to incorporate this compared to what the Senate has. If we can get on the same page pretty much, or we can get them on our page, I think we have a better chance of having this move forward. And we do know that those two bills have been mimicked off of other states, specifically Idaho. And that's important to help carry something through where they're seeing success in the program out there. And I can speak to where I was on the Northwest when I was administrator up in the Northwest. We had a similar program. It works. It works. Helps keep people. So I think it's a good effort. The side by side, 218, 217, I'd do that side by side and try to match those. And I'd put the time and effort there, Mel, rather than putting it in a 623. You're a signer in both those things anyways.
I like the idea.
But put 623 on it.
Oh, yeah,
Yes,
you can
right,
put
yeah.
623 there too.
Right,
But
yes.
it's going to have to come together.
Yeah,
Yeah.
great. Yes,
A question for Representative Myler about the amendment. For the grant, are partial years factored in? If a teacher were to stay only part of a year and then had to leave, would they get half of the amount for a given year, or is that just not factored in?
Good question. I don't have an answer to that question. My presumption is that the grant would not be awarded until at the end of the
completed the
They have to-
contract
Yeah.
year.
complete the contract.
Yeah.
Yes, yeah. So they're always in a year in arrears, yes, yeah.
Okay, thank you.
any further comments on 623? And I think we've, at the same time, talked about 218 pretty much in terms of where we wanted to go to look at a comparison between the three bills heading into. I don't think we need a further meeting until November. I think we can deal with it at that point, if that's okay.
Yeah, can I say one more thing?
Sure.
623 is very specific to, it talks about the university system.
No, not anymore.
Okay, so we're taking that all aside. Good, it's all gone. That's great.
It's a straight rate.
Yeah.
So it's starting to shape up like the other two bills. Yeah, yeah. Good.
Any further comments on either of these two bills, or are we good for the day? And thank you for the new members joining us recently. Sorry you had to wait so long. But thank you, everybody. And I guess we're done for the day.
So what she should do is make a side-by-side of the amended 620.